A New York court has agreed to review whether the state's strict new gun control laws were rushed into law in violation of the state constitution. And we're joined by WGY legal analyst Paul Harding of Martin, Harding and Mazzotti. Good morning, Paul.
Good morning, guys.
Hey,
So
Paul.
this is over the process itself, not over the constitutionality of the law, correct?
Yeah, you're absolutely right. There's, Article 3 of the Constitution has what happens in nearly every single bill, that there's a 3-day waiting period before they vote on it. So they get this final bill, and it kind of sits there, and then there's a 3-day review process. And nearly every bill, in fact, when I looked, I think every bill this year, with the exception of this one, did go through the 3-day period.
So, but the governor used his, executive powers to get this through, and so this is what these plaintiffs are arguing, that it was unconstitutional the way it was pushed through.
Exactly so, but the governor has the ability to certify the necessity of a bill, and it's his judgment that they look at. And so what they're doing is they're saying, okay, we know the governor has the right to do this. He can certify the necessity of something and then waive this 3-day period. But what they're attacking is that, did the governor make the right decision? And the courts have been clear on this. 2005 case that really in Court of Appeals just set it forth and said the governor, his decision as to whether the certificate of necessity is allowable, it's up to him. Meaning, we can't look at it. The recourse simply is for the legislature not to vote on it and say, hey, we're not going to vote. We want to wait 3 days. But once they vote, they can't go back and say, geez, Governor, we think you used the wrong rationale. If the governor uses this, it's really not, or up to this point, when it's been attacked, the courts have been clear saying, we're not going to review the governor's reasons for doing this.
Now, they're arguing that the law violates the guarantees of free speech, property ownership, and the right to petition the government. Now, this is just a group of regular New Yorkers representing themselves.
Sure.
What does that say to you about the fact that the court has agreed to hear their case?
I guess that's the stuff that's kind of mystifying here, because when you look at the rules, the governor has a right to do it, and it really is not a reviewable process, as I said. But what they're saying is a little bit different here, saying, well, as opposed to the other times this was invoked, this is a fundamental right argument, meaning this is the gun control. This is one of our fundamental rights to carry arms, and they're going under that area of attack, and we'll see. I think that the court, by looking at it, we could end up with a decision, again, a lower court's decision, Supreme Court, downstate Supreme Court. We don't know what they're going to say, but the Court of Appeals, the folks who in 2005 made that decision, we sort of have that same court sitting there today. So if there is a funky decision down in the Supreme Court, I think the Court of Appeals is going to speak on it and probably reaffirm the 2005 opinion, allowing the governor to do this. Politically, there's a lot of energy around this.
Do you think there's any chance they'll even issue an injunction before they come to this ultimate ruling that you're saying is pretty clear right now?
My opinion is no. We have a little saying up here, we call it upstate. That's what they call us anyway. But some of the downstate judges, and the reason why they picked that venue or picked that location to bring it, some of the downstate judges sort of can kind of go a different direction if they feel strongly personally about something. So my opinion is nothing's going to happen, but if it does and there's injunctive relief, wow, there's going to be some fireworks.
And I don't know, we got to let you go here in a second. I don't know if you've looked into this question at all, but do you think if you were to challenge this law, what do you think would have the greatest odds of being successful? Where is it most vulnerable, constitutionally speaking?
Yeah, the constitutional speaking, I don't think this is the avenue to go. I think the governor had the right to do this, although they're going to recertify that he in fact did. You look at the law, and of course, one of the things in there, they're saying, well, we're going to limit it to 7 rounds in the magazine. Well, they don't manufacture those, right? So now we've got this thing. It's the way that the constitutional, it's going to be a constitutional argument, and the way that it just looked politically motivated. It looked like, well, we're going to be the first state in the country to pass these rules, and looking at the fact that it was flawed and it was rushed through, and just ask for it to be go back on the floor to be voted on and therefore reevaluated. And that's sort of what the Republicans are kind of saying. Hey, there could be massive changes. There's going to be changes. They might be massive. So I think from the court's perspective, they're just going to sit back and they're going to wait to see what is brought in the legislature.
So they're hearing this case on Monday, so I'll have to wait and see what happens.
Okay, yes, absolutely.
WGY legal analyst Paul Harding of Martin, Harding and Mazzotti. Thank you so much.
Thank you, guys.
Thanks, Paul. Take care.